Mr. Yost makes $55,000 a month. So it doesn't matter if my client needs $3,000 a month to live off of, or she needs $9,000 for extra expenses and a standard and the quality of life that she's accustomed to. That is still need. I'm fine with moving the discovery issues, Your Honor. We're still here. We've got 50 minutes. We can at least take even if it's the motion to modify spousal maintenance, we are more than capable of dealing with that over Zoom and handling that this afternoon, so we don't have to continually drag this out and move it to another date, which I'm sure will probably be early to mid-April. We're ready to proceed.
Sorry, Matt.
That's okay.
Your Honor, as the motion for spousal maintenance, that's going to involve competing experts. That is not something we're going to be able to do over Zoom, Your Honor. And that also ties in with the motion to compel and for advancement of funds, and also the denali, Your Honor. We have issues involving the domestic relations affidavit filed by Ms. Yost, and I think she's going to need to be sworn in to go over her expenses.
Right out of the gate, this case is already setting up to be a high-stakes financial showdown. We're not talking about small numbers here. This is a dispute centered around a man allegedly earning $55,000 a month, and a former partner arguing that her need isn't just about survival, it's about maintaining a lifestyle. That distinction? It's everything in cases like this. Now here's where it gets interesting. On one side, you have an attorney arguing that need is flexible, almost subjective, based on the standard of living during the relationship. On the other side, there's a clear pushback. Should an ex-spouse really be entitled to luxury-level support indefinitely? And as this unfolds, pay attention closely, because this isn't just about money. It's about definitions, legal strategy, and how both sides try to frame reality in their favor. The tension is already building, and we haven't even gotten to the real conflict yet.
Claims $4,000 a month every month for attorney's fees, Your Honor, amongst one of several expenses that are questionable. So this is not something that is appropriate over Zoom.
Give me a second to review. And Angela, I misplaced my docket notes. They're buried on somewhere in here. Can you have the ability to print those out for me, please? Now, the expert witnesses, what motions were those for?
We disclosed we had an income analysis done of Mr. Yost, Your Honor. That was disclosed on January 17th through Jeff Querin. So the only part of the motion that we have dealt with that obviously is the motion to modify spousal maintenance. If the court would recall, initially when we filed this case, we're the petitioner, we had set spousal maintenance at $9,000 a month. And the court actually called me, this would have been through the ex parte temporary order, inquiring as to when the last year of tax returns we would have had available at that time, and that was 2018, which Mr. Yost at that time had made significantly less than what he had made over the last 3 years that we've averaged. So at the time, maintenance has been set based off of an income of Mr. Yost around $338,000, $318,000 or somewhat. And the report we've had from this income.
Notice what just happened there. The attorney immediately reframed the definition of need. Instead of focusing on basic survival, they're anchoring the argument to lifestyle continuity. That's a powerful legal tactic. Why? Because if the court accepts that framing, then the conversation shifts from what is necessary to what is expected. But here's the catch. Courts don't always agree with that broad interpretation. There's often a balancing act between maintaining a prior lifestyle and encouraging financial independence after separation. And right now, both sides are positioning themselves for that exact battle. Also, listen closely to the urgency. They are pushing to move things forward quickly. That can signal confidence, or it can be a strategic move to avoid deeper scrutiny. Either way, this is no longer just procedural. It's becoming tactical.
Analysis that Jeff Querin has done 7 weeks ago has his income average over the last 3 years at $664,000. So again, that's not brand new news. Again, that report was issued and sent to Mr. Thompson within a couple of days, if not on January 17th. So I mean, there's been ample time to respond to that. Frankly, if we're disclosing expert reports by statute, Mr. Thompson would have had to have a responsive expert opinion within 30 days of receiving notice of us issuing that report. So that's not been done. We're outside the 30-day window. So I really don't know what the dispute is on this motion with respect to the spousal maintenance, besides trying to continue to delay this matter. So again, we're ready to proceed. It's all argument. There's not any need besides the domestic relations affidavit or sworn statement. There shouldn't be any need to question anybody on the witness stand. This can be done through argument.
Your Honor, and I disagree completely. If we review Ms. Yo's domestic relations affidavit, every single expense that she listed, she deems as estimated. Every expense without a single exception. As the expert report, if I have a reply to their expert report pursuant to the rules of civil procedure, that's 30 days. I can have an independent expert, separate and apart, Your Honor. I have a demonstrative exhibit, which I anticipate. Let me try to be as succinct as I can. We cannot get this done in 45 minutes. Any one of these motions, Your Honor. Any one. The domestic relations affidavit is riddled with, well, they're all estimates. I'm entitled to inquire of Ms. Yost as to what her actual expenses are, because she has not provided a single solitary actual expense to justify any deviation from the court's order of spousal support. None, Your Honor. Everyone's an estimate. And the court cannot make a determination based on pure estimates by the party requesting a modification of her own spousal support award.
There's no case law to discuss.
And here comes a resistance, and it's immediate. The opposing counsel is shutting down the idea of handling this quickly, and for good reason. When expert witnesses are involved, especially in financial cases like this, things get complicated fast. What they're really saying is, this isn't something you can rush. Why? Because once you bring in expert analysis, income reports, financial breakdowns, you're dealing with interpretations, not just raw numbers, and that opens a door to disputes, cross-examinations, and challenges. But here's the deeper layer. Delaying a hearing can sometimes benefit one side more than the other. Whether it's gathering stronger evidence or simply buying time, delays aren't always neutral. They can be strategic. So now the question becomes, is this about fairness or advantage?
Discuss that, Your Honor. Estimates are commonly used because a DRA has to be filed prior to the time of trial. Usually most pretrial conference orders require 10 days in advance of trial or 30 days, depending on the court and jurisdiction you're in. At that point in time, it is very common practice to have the exact amounts put in. Otherwise, you put estimates in. That is something I've commonly done in 15 plus years of domestic practice. And frankly, if we're talking about my client's expenses and we want to get into the analysis on spousal maintenance, it really doesn't matter, because need doesn't have to show. Of course, we're talking about need versus ability to pay. Clearly, there's an ability to pay. Before we start talking about need, it doesn't matter if my client is destitute or has to live or needs the exact amount of money she's requesting by spousal maintenance. It is need as a standard of living. Mr. Yost makes $55,000 a month. So it doesn't matter if my client needs $3,000 a month to live off of, or she needs $9,000 for extra expenses and a standard and a quality of life that she's accustomed to. That is still need. And that's what we're dealing with here. Again, there's been ample time for Mr. Thompson to respond to Dr. Querin's report from January 17th that we provided to him. We are ready to proceed. This has been set on the court's calendar for a number of weeks. We need to get moving on this immediately. There's no reason to have a half day or a day long hearing over motions to modify a temporary order. It's not that complicated.
I'm sorry. And Your Honor, I'm astounded Mr. Olson made the argument that need is not a factor. Need is most certainly a determinative factor as to spousal support. And the court cannot make a decision when not just one or two, every expense is estimated. And it is not for the time of trial. She is asking for a change right now. So the need right now is what we need to determine, not what she may think she needs in a year or two, which I don't even know where she's coming up with these numbers, Your Honor. Most certainly.
Now this is where things start getting a bit more contentious, because the focus shifts directly onto the credibility of the financial claims. The mention of a domestic relations affidavit is critical. That document is supposed to provide a clear, honest breakdown of income and expenses. But instead, what we're hearing is skepticism, specifically about $4,000 a month in attorney's fees and other questionable expenses. That word, questionable, is doing a lot of work here. It signals doubt, and more importantly, It invites a court to look deeper. In cases like this, credibility can make or break the outcome. If the judge starts to believe that the numbers are inflated or unreliable, it can completely shift the balance of the case. And right now, that doubt is being planted very deliberately.
May I at least inquire, my clients are, a bit of a hard spot financially, which is ridiculous considering the assets that these parties have available to them. One of the things that we've requested in our motion, one of them was that under the temporary order, there was a savings account through Credit Union of America, I believe, that had about $318,000 in it. And part of our temporary order had that account being split. Can we at least either address that, or the court would grant my client some advancement on property settlement, even if it's $20,000 or something like that, since we're going to be pushing this out till the end of April. I know I'm not trying to downplay $20,000 is a lot of money. It is not a lot of money for the assets involved in this case, and Mr. Yost is in control of all of them. So if there's some just temporary relief that my client can have, and again, I say that in the sense of advancement on property settlement, because if the court orders for her to be awarded an advancement on property settlement of $20,000, it's not that money just goes away and is forgotten. That would be a line item on a marital estate spreadsheet that she's already received that money prior to the court's final disposition or whatever agreement can be reached if ever it comes to that. So again, with this being April 30th now, before we're going to be able to bring this up again, we would ask for at least some temporary relief that is not an amount of money that there's not cash available to do that. It makes no sense to me that that would be something that would be contested, I guess, because of the financial.
Now we're getting into the numbers, and this is where things start to escalate. The attorney is laying out a major shift in income from roughly $338,000 annually to an average of $664,000 over 3 years. That's not a small increase. That's nearly double. And why does that matter? Because spousal maintenance is heavily influenced by ability to pay. The higher the income, the stronger the argument for increased support. But here's a strategic move. They're also pointing out that this information isn't new. It was disclosed weeks ago that that's a subtle but important jab. It suggests that the opposing side had time to respond, and didn't. And in legal settings, timing can be just as important as the facts themselves. If one side appears unprepared, it can weaken their position significantly.